Welcome back to Lawgical with Ludmila, where we untangle the legal knots so that you don't have to. I'm Ludmila Yamalova, a lawyer based in Dubai. In each episode, we break down complex law into clear, practical insights that you can actually use. Today, we're talking about a subject that touches every family sooner or later, called probate. Specifically, the DIFC Probate Roadmap, a structured guide to managing inheritance through the Dubai International Financial Center, or the DIFC. The specific episode draws directly from our firm's own DIFC probate experience and our internal roadmap, which consolidates real, hands-on procedural knowledge. This roadmap brings much-needed clarity and process in an area that until recently was fragmented, uncertain, and intimidating, especially for expats. So let's talk about the legal backdrop. Historically, as many of you would know, inheritance in the UAE fell under Sharia-based federal law. That meant, unless otherwise specified, assets were divided according to Islamic inheritance principles. For many foreign residents, that created anxiety and confusion, especially when their families or assets span multiple jurisdictions. The DIFC, which is the Dubai International Financial Center, introduced a solution, its own wills and probate framework, allowing non-Muslims to register wills under common law rules. The DIFC Wills and Probate Registry was established to give expats a secure, legally recognized system for managing succession in Dubai and later other emirates. So in terms of the probate roadmap, registering a will is only half of the story. So when the testator passes away, their executor must apply for what's called a probate, which is the legal authority to administer the estate. Over the years, as more wills were registered, a growing number of families began using the DIFC courts for probate. But the process wasn't always clear, especially when the deceased left assets across multiple emirates or abroad. To address this, the DIFC courts developed a number of rules aligning the process with its procedural laws, including the DIFC Wills and Probate Rules, the DIFC Courts Probate Rules, and in particular Part 56 of the rules, and the new Digital Wills Portal, which is very important, and that supports online filing, authentication, and document management. So this roadmap effectively turns what was once a complex cross-border puzzle into a defined step-by-step procedure. And just by way of reminder, the DIFC is a subset court within a bigger UAE legal framework and within Dubai. So in the past, you could have a DIFC will, and the presumption was that you'd have the DIFC will, but how you'd probate, i.e. how you enforce it outside of the DIFC jurisdiction, was a fragmented process. But over time, the DIFC courts and the DIFC wills and probate, they have ironed out all these sort of the relationships with the different authorities and different government entities within not just the Emirate of Dubai, but across the UAE, which has now resulted in a fairly smooth process for not just the registering of a will, but not just probating it, but also then ultimately transferring assets as per the will. So, which in many cases involved assets that were based not only in the DIFC but outside of the DIFC, and not only outside of the DIFC but also outside of Dubai and other emirates. So, as of now, if you have a DIFC will, and when it gets probated, the enforcement of that will, and in particular the transfer of assets, happens very smoothly, all under the umbrella of the DIFC courts. There was a time when you had a DIFC probate order, and then you had to go to a local court and kind of ratify that order through the local courts, and then with that local court order, you would go to depending on which emirate the asset was located in, and then try to and then ultimately transfer the asset on the back of that specific court order. So if you had, for example, assets in Ras Al Khaimah and Abu Dhabi, you'd have to get that probate then verified through the Dubai courts, and then with that Dubai court order, go to Ras Al Khaimah and go to Abu Dhabi and try to transfer assets on the back of that. Sometimes it also even required their own court orders from Ras Al Khaimah and then from Abu Dhabi. So the process was a little bit choppy, which was naturally going to happen given the novelty when the DIFC Wills and Probate Center was introduced and the whole process. But by now, the process is quite smooth. We've gone through it, sadly, several times, and that's because a number of the clients actually for whom we registered wills have since sadly passed away. And in some cases, we've had clients who had registered the will with somebody else and then since then have passed away, and their executors have come to us and solicited our help. So we have kind of gone through this process ourselves, and this is the purpose of this discussion today, is to give you the hands-on practical experience and sort of a view and a roadmap of how it happens in real life. And the gist of it, so the highlight, is that the process is so much smoother right now. It's almost like a step-by-step, which I will walk through shortly. And in particular, I guess it's a huge development or evolution as compared to how things were. And then when I mean that things were involving the DIFC Wills and Probate Center. And back then, there was a time when, although you had a will and you had an order from the DIFC courts, but enforcing it throughout the UAE was a lot more complex than it is today. Now it's a lot smoother, and here's why. So at a high level, the process is, starts with obviously registering the will. So you need to have a valid DIFC will, and it has to be registered with the DIFC Wills Service Center, which ultimately confirms the testator's intent, and the testator, basically the person who is leaving the will, and it also confirms the domicile and compliance with the DIFC rules. That's the first step. That's the will. Once if the time comes for probate, then obviously the death notification application. When the testator passes away, the executor or the family representative then must file what's called a probate application within the DIFC courts. And this is just a high-level kind of overview. I'll go drill down into each one of these steps shortly, but this is just a high-level roadmap. And then you have the death notification, and then you have to file the probate application. After that, the court grants what's called a grant of probate, and then which gives the executor the legal authority to then administer the estate, and that means to collect, manage, and distribute assets. And then the executor then carries out all those duties in line with the will, including liaising with banks, land departments, and other authorities inside and outside of the UAE. And then the DIFC courts coordinate enforcement through the MOUs, Memorandum of Understanding, with other UAE authorities, as I mentioned earlier. Now there's specific MOUs that exist between the DIFC courts and other specific government authorities, which ultimately allow for these wills to be recognized and with other authorities outside of Dubai, and also with the courts, other local courts, as well as courts abroad. So before diving deeper into this roadmap, it is important to clarify just 4 fundamental terms that appear throughout the probate process and our discussion today, which is beneficiary, executor, trustee, and representative. So these are 4 different designations. They may or may not be all in one person, but they each carry a distinct legal function, and misunderstanding them can easily create confusion later. So in terms of understanding the probate process and application, it's important to kind of just highlight the definition, or just remind the definition of each one of these designations. So the beneficiary basically is any person or entity that is named in the will, who will receive part of the deceased estate, all or part of the deceased estate. They may include family members, friends, charities, or even corporate entities. Beneficiaries, generally speaking, this is important, they have no power to administer the estate by virtue of being named as beneficiaries. So their role is only to receive what's due to them once the executor completes the distribution. So in other words, beneficiary, although they may receive 100% of the estate, but by just virtue of being named as beneficiary does not give them the right to actually administer the estate. That is reserved for the executor. So in DIFC proceedings, every beneficiary must be clearly identified in the will, with their relationship and contact details recorded to ensure proper notification and ultimately disbursement. Now, the executor is the cornerstone of any probate process. Again, probate is basically enforcement of a will. So the executor is appointed by the testator in the will, and the executor has the legal authority to manage the estate. So from applying for the grant of probate to collecting assets to paying debts and distributing inheritance according to the will. So under the DIFC rules, the executor must file the probate application and then provide a witness statement confirming their identity and intent to act, and then ultimately administer the estate honestly and transparently as a fiduciary, meaning they owe legal duties of care and accountability to beneficiaries. Now, the executor and the beneficiary can be one and the same, but if they are one and the same, still they need to be listed out as separate designations. So you need to mention clearly who the beneficiary is and mention clearly who the executor is, even if the executor is the same as the beneficiary. So the trustee is also another term that sometimes comes up. The trustee manages assets that they have been placed in trust, which may be established by the will or separately. So, and unlike an executor who acts until the estate is settled, a trustee's role can continue long-term overseeing property or funds for minors, dependents, or specific purposes. In the DIFC matters, a trust can fall under the DIFC trust law and the foundations law, both allowing expats to structure wealth with continuity and control. And then you have a term that's called representative. So representative can be often a lawyer or a law firm, or it could be an accounting firm, and acts on behalf of the executor or on behalf of the applicant in dealing with the DIFC courts. So they submit the filings and they communicate with the case progression officer. They can attend virtual hearings and they ensure compliance with procedural requirements. So representatives file their own witness statements in addition, so the executor files their own witness statement, and representatives as well must file their own witness statement confirming authorization under power of attorney. So while they manage the process, the executor remains legally responsible for the accuracy of all information submitted. Why the representatives are important is that, for example, and this applies to us in several cases where the executor could be appointed as a family member or some sort of a relative or a friend, but ultimately probate is a legal process. It involves application to the court. It involves submission of legal forms. It involves quite a bit of sort of document management and hand-holding, and also explanation of various aspects of the will, and ultimately also administration of these assets and transfer of assets. And depending on the complexity of the will, you could have multiple beneficiaries, you can have even multiple executors, and you can have multiple assets that are distributed in different and to be divided up in different proportions to different beneficiaries. So the idea is that it may sometimes make sense and be more appropriate for a lawyer, a law firm to help manage that process, because there's a lot of technical and legal issues that underline kind of a probate or enforcement of a will. So that's why, in addition to the executor may actually want to appoint, and in many cases do appoint a law firm. And obviously our clients' cases, it's us as a law firm to hold the executor's kind of hand and explain to the executor and sort of either work in parallel with the executor or actually act on behalf of the executor to manage the process as much or as little as the executor believes is necessary for that will to take effect. So understanding these different roles is important because it helps families plan effectively. So if these functions are not clearly assigned in the will, or if executors and trustees are unwilling, for example, unqualified or unavailable, the probate process can obviously stall for months. And so that's why there's the DIFC kind of probate, and the roadmap that we're here discussing helps kind of ensure each role is recognized and documented, reducing ambiguity at a time when clarity means and matters most. So in terms of the application documents that are required at a high level, so every DIFC probate application begins with a standard set of documents, and some that depend, some of them depend on circumstances, but more or less they're kind of a standard set, if you will. So you start with what's called the probate application form, and in fact I even printed out to show you what it looks like. Is it's these are legal forms. So this is, for example, the probate application form. So it's a document that's downloadable from the DIFC website. and it's a court form that needs to be submitted as part of the to begin the process. So then the second document that needs to be submitted is what's called a witness statement from the executor, and that's basically another document. Here, this is kind of witness statement, and that basically confirms the identity, role, and intent to act. Now the DIFC conveniently has its own sort of sample of a witness statement, but you can modify to the extent that's relevant. But more or less, there's a template exists. So that's the second basic document. Again, that's all available through the DIFC portal. And that's kind of that's the first document. That's the second, also if you have multiple executors, you'll have to submit a joint executor statement. If that's in the event, sometimes the will does mention more than one executor. And also whether they're appointed to act jointly or formally renounce their role. So that's an additional document. And then there's the representative statement, and that in this case would be the law firm, for example, like ours, who represents the executor, and that representative must also file a statement. So we as a law firm also have to file a statement. And then there's in the event, the will also provides for guardianship. So there's also the guardianship forms and statements. And that includes, the guardians must submit their own witness statements and then their own separate application. These forms and applications exist through the DIFC portal. And then the big one is also, and this is not to be underestimated, is the list of assets. And this is important because once I'll kind of go through the entire process, is that it's important because ultimately the DIFC courts will issue a probate order that will specifically address these assets. On the back of this probate order, it will issue letters to specific authorities where these that have authority over these assets. That's why a list of assets is important. And the list of assets needs to be both in English and Arabic, and only sort of the assets listed, the ones that are listed in this application will appear in the final probate order. So this is very important because, and also it's important for those who are considering doing a will, because in some of our clients' cases, they are reluctant to, for example, list out specific assets. They may just want to just mention generally which is possible and does not invalidate the will. But ultimately, for purposes of probate, if you want to make it easier for your loved ones to later be able to probate and kind of manage the estate, having a list of assets kind of at the outset and in sort of consolidated form is highly helpful, because in that case, for example, if they are listed as part of the will or attached as an attachment to the will, then the executor and or representative will be able to use that specific list of assets as part of the probate application form, and then that will be the list that will ultimately be reflected in the final probate order. And that will give the authority to the executors ultimately to transfer the assets. And therefore, omitting or missing any of the asset means you have to file a new application. Now, just because it's not in there does not mean you've lost your chance. You'll just have to file a new application every time you uncover another asset. So in these steps of these forms that I've just kind of described, and that's in addition to the documents I mentioned earlier that need to be submitted as part of this, including the death certificate and the ultimate will. So they're not optional. They're sort of procedural safeguards designed to keep the DIFC probate system transparent and accountable. So now let's kind of go through a little more level of detail, more kind of hand-holding the step-by-step process. So based on our experience with the DIFC probate process, kind of unfolds as follows. First, you start with identify the executor, right? So confirm that the applicant is the person named in the DIFC will. If there are joint executors, either they must both act together, or one must show the other has renounced or is unresponsive. So this is important because in some of our clients' cases, we have had multiple executors listed. So now if they're both jointly appointed, then they will have to work jointly. And if one of them is not available, there has to be a very clear document submitted as part of this formal court process that clearly explains, either submits a document from that executor renouncing their interest in administering the estate, or showing that the executor is not available. And we, by the way, had recently a case like that, where one executor was based outside the UAE, another one was inside, and the one that was outside, it sort of was impractical for them to actually be administering the estate. So this is also important to keep in mind for the testators or who are drafting a will, to keep in mind if you're going to appoint somebody as executor, or if you're going to appoint especially multiple ones, remember that whenever you have two, it may be more complicated for them to act together. And also if they're abroad, it also may be more impractical for them to do so. So I guess, but there's always a solution to that, as if the executors can always appoint a representative law firm or anyone else to kind of on their behalf to act and help them manage the process. So then you have to prepare all the pre-application documents and gather and legalize, by the way, all these documents. So the death certificate, it has to be legalized for the purpose of the UAE. So this is important because we've had, right now having several issues like this where the death certificate is from Slovakia and the beneficiary and the executor is based in Spain, and we're the representatives here, and they're just trying to get a copy of the legalized certificate is not so simple. Because you need to ultimately get the original certificate and have it attested from Slovakia, but the beneficiary and the executor is based in a different European country, so arranging with the authorities who actually legalize and translate these documents. It's quite a process. But it is important to highlight that if the person passed away, the testator passed away outside of the UAE, the birth certificate will need to go through the full legalization process with attestations. And so there are specific agencies that work on this. We particularly work with an agency called Argentum. They're very responsive. They're the ones who are now helping pick up the original from Slovakia and bring it to Spain, and then from Spain to have it kind of be legalized and ultimately brought to the UAE. So, but that is a must step. Remember, so just kind of keep that in mind because we have multiple, actually, unfortunately, probates that are going on right now, and they all involve these kind of nuances between different countries and the legalization process. Then also you need to have the power of attorney if the executor appoints a legal representative. So in this case, let's say it's us. There has to be a legally documented power of attorney that is valid under the UAE laws, which basically means it should be a UAE power of attorney. And then you have to compile the full application, which, as part of this representative set of documents here, it should include, in addition to the probate application, so the legalized death certificate, the POA from the executor and representative's witness statements, and then the registered will, and the list of the assets, and then the supporting ownership evidence, for example, title deeds, bank statements, and trade licenses. This, by the way, is also very important. So in addition to the list of assets, it would be very helpful to have, in fact, we've been required to submit a copy of the title deed and sort of bank statements and the trade license. And that's advised to all those testators who are either thinking of drafting a will or hearing this podcast or considering amending. You can amend, but it'd be better, it would help your executors and the loved ones that are left behind to help enforce and manage the estate if all these documents, including ownership documents or evidencing the ownership of various assets, are, if not included in the will, but are readily available for the executors to be able to submit to as part of the probate application, because they are required. And that would mean title deed, bank statements, trade licenses, whatever other certificates of ownership of cars, vehicles, boats, aircraft and such. So now you've gathered all this here, and that now you submit everything through what's called the DIFC courts portal. And that's a pretty magical space, as so many services, government services in the UAE these days are. So it's just one portal, and it's very user-friendly. You just submit all the documents, and everything else from there at that point on kind of is managed online through this portal. And by the way, kind of as a high-level comment, overview comment, is just it is all done online, remotely, but it's highly secure. So it's a pretty smooth sailing in that sense. Nobody's required to personally appear here, even if executors and beneficiaries are based in other jurisdictions. And we have recently been managing exactly that with 4 or 5 different touch points around the globe, and the DIFC courts, and especially because of their court portal, are pretty efficient and well structured and technologically advanced for this process to by now be run quite smoothly. So it's very, very user-friendly and sort of digitally friendly. So one more thing that's important is there's no court fee that applies. As part of this application, the probate application process. So all of this I just described and all the work that the DIFC courts are doing for probating these wills come for free. So this is quite big because it does involve quite a bit of resources from the DIFC courts representatives, but this is perhaps kind of a reminder for why the DIFC wills fees, which are not insignificant, are perhaps worthwhile, because as part of the probate, it's already kind of encompassed in the fee that you paid for when you registered the will. So all of this is done for no additional fees to the court. So the DIFC court portal is kind of your central portal, and then once you submitted your application, then the court assigns a case progression officer to review the file, and there's different representatives, and then they act as a direct liaison between the executor and the court, or between the executor and the representative of the court. So in our cases, obviously, we're involved at all times, and so it's us, and we manage the communications with the executor and the courts, and sort of we kind of like the middleman. And then once the file has been reviewed, so the progression officer, the case progression officer, CPO, they reviewed the file. If they have any issues, they come back to the firm and ask for this and that. And this is how we tell you, I'm sharing with you now, they want to see a list of assets, and they want to see all the documents, the evidencing the ownership of the assets. So they come back and forth to you before they schedule a probate meeting. So all of that is done, and then once the file is complete, and then they schedule a virtual or in person, if somebody wants, a probate meeting. And that's with the executor and the representative, the lawyers, for example, to sign documents and confirm basically the procedural accuracy. So in this meeting, the progression officer just confirms that the executor has reviewed the witness statement and it's accurate, and the representative has reviewed the witness statement and it's accurate, and they digitally sign, so that they've confirmed. It's all managed through the progression officer through the DIFC court portal, very secure with QR codes and multiple screens, and sometimes maybe a little overwhelming, but more or less technologically manageable even with our elderly clients. Once the probate meeting has taken place, which is quite short, maybe it takes all in all 10, 15 minutes maximum, managing the different parties across the world and signing, basically reviewing the statements and signing through a QR code. Then the court issues what's called probate notice, and so there's a 2-week public notice that's published on the DIFC court's website to allow any objections, if any. So that's for 2 weeks after the probate meeting. After that, if nobody objects, then after the notice period, the grant of probate is issued, and the executor in the executor's name. So it's called the grant of probate. So that's kind of the key document. And as per this grant of probate, it authorizes the executor or the representative, it could be the law firm, to manage and distribute the assets. So this is the key documents. And then on the back of this key document, being the grant of probate order, the DIFC court then also issues letters to relevant UAE authorities, such as Dubai Land Department and local banks, instructing them to act directly on the order. So and these letters, by the way, are bilingual and stamped by the court, making separate enforcement through Dubai courts unnecessary. So this is what I mentioned earlier. In the past, that wasn't the case. You would take the probate order, go to the local courts, depending on the emirate, and have that sort of ratified. And then on the back of that, request that court to issue different letters in Arabic to the different agencies and banks then to transfer the assets. Now it's all done under the same umbrella, being the DIFC courts, and because the DIFC courts also obviously they're bilingual, so all the letters are by default are being issued in both languages, which makes the whole management and transfer of assets that much smoother. So you don't have to get a letter which how it used to be before in English and then have it legally translated. Now every document from the DIFC courts comes in both English and Arabic with the court stamp, so you go with that same document, and it's addressed to a specific authority. It could be land department, could be the bank, could be RTA, or any kind of economic zone, and with that letter you go, and because it is, although it's a DIFC court letter, right, and you're acting outside of the DIFC, but because by now this process has been so cemented and established that now all the authorities within the UAE act on the specific letters from the DIFC courts as if it was any other sort of local court. So this is very important to highlight. And then in terms of the fees, while there's no fees, and I mentioned earlier, payable to the courts, there will be transfer fees that will be paid. So and that's, for example, if you transfer the property, if one of the assets is property, there will still be transfer fees applicable to be paid to the land department. Now, the percentage of the transfer fees depends on the relationship between the testator and the beneficiary. So if it's a family member, there's just a transfer fee of 0.1 to 0.5%. If it's not, if it's an unrelated family member or an unrelated member of the testator's sort of social circle, then they will be subject to the 4%. So depending on the relationship between beneficiary and the deceased. So those are the fees will still remain. So it's kind of like if you were buying property or selling property, those are the fees the government you still have to pay. So they're not subject to any like a specific, or they're not exempt, in other words, from these ordinary fees that apply in sort of in other otherwise. So practical insights from these real cases. So from our firm's experience, the most common delays arise when executors are abroad or unresponsive, when guardianship clauses are not clearly defined. When asset documentation is incomplete or untranslated, which I mentioned before, when death certificates are not properly legalized, or when, for example, the assets that are subject of the will are either have some sort of debt or liability attached to them. So, for example, unpaid land department fees or unpaid service fees. We had this recently when asset or one of our clients whom we're helping with the probate right now for his late wife. The property that is being transferred, actually over this period of time, obviously he's lost his wife and he's based in the UK and they're more elderly, and so the property has not, or the owner of the property, who is his late wife, as the service fees have not been paid. As a result, the property now has this liability, and in fact there was even a court case, RDC case, that was filed for the non-payment of service fees. So as a result, as part of this process, we had to first settle the service fees, obviously from the estate, to be able to transfer the asset from the testator to her beneficiary or her husband. So these are kind of the sort of some of the things that keep in mind as part of the probate process that can come up and therefore complicate issues. So the legal takeaways, the DIFC probate applies only to, this is important, to non-Muslims. So this beautiful process, beautiful, I guess under the circumstances probably is not really the right word, but ultimately a smooth process of probate that I just described, it does only apply to non-Muslims. And so in this process is, as I said, independent from the onshore Dubai courts, but the DIFC grants are recognized for enforcement across the UAE institutions. Executors must maintain accuracy and transparency, especially in listing assets and guardianship details. And then legal representation helps ensure compliance and smoother communication with the DIFC courts. Why this specific topic matters and this roadmap, it's not just kind of procedural improvement, it's a confidence building milestone for the UAE's legal infrastructure. It tells families and investors that the UAE now has a predictable court-backed succession pathway. And for expat, it means certainty, knowing their assets will be handled according to their will. Efficiency, probate proceedings can now move faster and digitally. And recognition, the DIFC grants are increasingly accepted by UAE institutions and foreign authorities alike. And as for practitioners, it signals that the DIFC Probate Court is evolving into a specialized forum for cross-border succession cases with technical capability and procedural consistency. So from a practical standpoint, kind of as a parting advice, if you are a resident in the UAE and you have assets in the UAE, review whether your succession plan includes a registered will that's complying with the DFC rules if you're non-Muslim, clear executor nomination, asset mapping across UAE and foreign jurisdictions if you wish to include those, and then translations and attestations where needed for enforcement. So these small steps can prevent major complications later for your family and for your estate. So in conclusion, the DIFC probate process represents a major step forward, bringing clarity, predictability, and confidence to inheritance law in the UAE. It reflects a broader evolution of the UAE's legal system, one that respects local tradition while enabling global best practices. And in essence, it means families can now plan with certainty and investors can act with security, and the law can operate with transparency. So that's all for this episode of Lawgical with Ludmila. If you found it useful, visit lylawyers.com for more insights. We're also on Apple Podcasts and Spotify, and you can also watch our video episode on YouTube. Until next time, stay informed, stay safe, and keep things logical.